Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. We are in the studio with attorney Jeff Roberts, who does a lot of work in the Social Security disability area. And we're going to talk about a significant change that happened this past June, which is actually going to be a pretty good benefit to your clients. Jeff, how are you, guy?
I'm doing good, Jim. How are you?
I'm doing well. Hey, I'm glad to hear this. We've talked about Social Security disability in various podcasts, over the years, but this is a pretty good change, and it's actually going to be fairly beneficial. So why don't we break it down? This has to do with something you called a job history look back. Do you want to kind of talk about that a little bit?
Sure. With Social Security disability or SSI disability, whenever the judge or Social Security Administration is looking at whether you have any transferable skills, this tends to apply primarily with older workers who are seeking Social Security disability or SSI disability. They look at transferable skills. If you cannot go back to the type of work that you've done in the past, then they're going to look, when they're looking at whether you can go back to any of the jobs you've done in the past, they've always looked back over a 15-year time span. So if jobs you did 30 years ago, they didn't pay any attention to, but they've looked over the last 15 years and the job skills and the jobs requirements of those jobs over the past 15 years. And then if you couldn't do that, then they would look at the transferable skills. Those jobs would provide that may transfer into a job in the physical capacity that you could do. And so in that 15-year period, from a work standpoint, is a fairly long period of time because the jobs in different factories and other jobs change over a period of time. During my career, the first 15, 20 years of my career, the computer has blown up. From there, when I first started practicing, they were still using typewriters. We used computers and word processors for documents as well. But email, internet, all of those things was not really that relevant. I didn't use a computer a great deal back in that period of time. And so, if you look at a job that was down back in that time period versus now, or 15 years later after computers got very popular, how you do that job has changed drastically. And even still today, you still have that where job categories change and the way a job is performed changes over time. And so that has been an issue that I've had with clients in the past when they look back 15 years.
And I think the reason for this is you're applying for disability and benefits. So if there's a way that you could return to a type of work that you've done in the past, hey, maybe you don't need to have disability because they still have an option. So this change here, that's why they used to look back. Maybe at one point you sat at a desk and did some typing, or maybe you ran a cash register. Then later on you took on some other jobs and you got hurt, so maybe you can't do some heavy lifting. But hey, 15 years ago you ran a cash register, so maybe you could go work retail.
Right.
That's kind of the idea, right?
Exactly. And what you would see is when you were looking at that is from a Social Security standpoint, if you're under 50 years of age, this doesn't really make any difference because they're looking at, can you go back to doing any type of work? But when you get to be an older worker, the adjustments that you can make and that you can expect to be made in an employment setting are different from that. And Social Security does take that into account. So, the standard for 50 to 55 is one thing, from 55 and above is different than what it is for a 40-year-old or a 30-year-old. And so, like I said earlier, the older workers are the ones that the transferable skills come into play on from that standpoint. And what I would see at times is, for a very short period of time, you may have somebody who did a job for that they rarely ever did, but they did it for a very short period of time, 14 years ago, where, because they were out of work here, they went to work, they do factory work all the time, but factory shut down like here when Brick and Stratton shut down, and somebody may have got a job to go work at a convenience store for a very brief period of time.
Just to pay some bills,
Yeah,
basically.
exactly, and then got on at another factory where they're doing a lot of heavy lifting, et cetera, and they only did that cashier job for, 4, 5, 6 months. Well, the judge would look at that as a past relevant job that they've done, and then it would come into play on whether they could physically go back to that job, because that job may have been substantially less physically demanding than what they've done the other 35 years of the work life, or the transferable skills of a job like that. They may have, for a period of time, stepped into role of a supervisor type thing at a plant because the supervisor was out for an illness or something, and they just filled in, and then they look at that even though that wasn't something they really did for a long term. And so those type of things could come in and be damaging and basically really, really have a huge effect on the claim and cause the claim to be denied from that standpoint.
One of the things that has to be frustrating in that situation is it takes so long to get through the Social Security disability system and some of the medical testing and things like that the evaluations have to go on. You finally get to that point, and the judge says, "Oh, well, there was this time where you did this job for 6 months," and it basically kind of train wrecks, a lot of the progress you thought you were making.
Exactly, and I've represented clients in their case, and I talk to them about their job. That's whenever I meet with a client initially, the first meeting with a Social Security client, I've always talked to them about the work they've done over the past 15 years, because I know how relevant that is to their case and whether they're going to be successful, or whether I'm going to be able to be successful in their claim for them from that standpoint. So I want to know that 15-year work history, and then when we get involved and I get access to their Social Security file and I get a detailed earnings query from the Social Security Administration, and then there's a job that they had that was a very brief job that they didn't even recall because it was such a brief job 14 years ago, and I don't fault my clients for that at all. I would be the same way. And then I bring that up to them, and of course, obviously, they remember it when I bring it up, and then we discuss that job, but it can have a huge effect on their case in that setting. And we talked about there's been a change, and the change did come into effect in June of this year, where they've shortened that 15-year look-back period to a 5-year look-back period. Frankly, the look-back period is my term for it. That's what I've always called it, and other attorneys use the same term for it. But it's a 5-year work history that they're going back to look at now instead of a 15-year work history that they're looking at to see if you can go back to those jobs physically, and if you can go back to, or if those jobs provide transferable skills. And as a practical matter, I think that this change is a very good change for the system, for Social Security system, and also a good change for workers, and because of what I was talking about earlier, and that is, job process has changed drastically over time. And a job you did a long time ago, well, if that job is done completely different now, and you can't go back to doing that job, but they look at it and say, okay, these are what the requirements was. You got transferable skills to do that job, even though that job is not done quite the same way at this point, or there's other things that have been added to that job. Then you've got somebody who's totally disabled, who can't get work and can't go back to work, who's not getting disability benefits, and then they end up on other programs instead of what they've paid into to receive if it's Social Security disability, in getting the benefits that they basically signed up for when they first started working. In my opinion, I know some will disagree with me in that regard, but when they started paying in Social Security disability taxes or Social Security taxes, then
And that's
they
usually your FICA, right?
FICA,
When
yes.
you look at when you get your paycheck, you look at the summary that comes with it, and it'll say X number of dollars went to FICA.
Correct.
That's a big part of what this is.
Yeah, that's big. That's you're paying into the Social Security system, and from that standpoint, that's where you pay in is through the FICA taxes. There, you and your employer both pay in a share of that for that, and it's not. If somebody is totally disabled and they've paid into that system, and they meet the criteria, but there's this weird quirk in the law that says, well, we're going to consider a job 14 years ago that's really done differently now, or that's done differently at this point in time, and so that you can't do, then you ought to be granted disability in that situation, in my opinion. And now with shortening that time period back to 5 years, I think that's much better and much more accurate look back period to use, because in a 5 year period of time, the changes in the job should be something that you can adapt to some extent. From there, in the Social Security Administration, when they proposed this change and adopted it, that was one of the reasons they adopted it, is because they looked at the system and they talked to all the involved parties, as they should on any regulation change, and realized that 15-year look-back period was just too long, and it was causing people who should be receiving disability benefits not to receive those benefits.
Well, friends, and if you're interested in looking at what this job history form looks like, if you go back to episode 67, we published that a while back. Jeff did a full episode on what's called the Social Security Disability Form 3369, and that's basically that form where you're going to kind of list out kind of the jobs you've had, maybe kind of when you've had it. Maybe that form's going to be updated now. We might need to update that link on the show notes or in the show notes, but again, fewer blocks to fill out probably.
Yeah, it on the form, it talks about the jobs you've held in the past 15 years. I'm assuming that it will change to the past 5 years from the date of the application, or date you allege that you become disabled. And so I'm assuming that form has been updated since, or is in the process of being updated. It may have got updated before the June effective date of this.
In anticipation of the change.
In anticipation of it. It may have been afterwards. I don't know exactly from that. But even if you filled it out going back 15 years, if your hearing is after June, then you don't have to worry about that, that you went back 15 years on the form. The judge should only look at 5 years at
First
this
5
point.
years back. That makes sense. Jeff, at the outset, you mentioned that this change, this change in the look back period, affects both Social Security Disability Insurance, or SSDI, those are for people with a work history, but it also applies to people with SSI who are applying for SSI benefits, supplemental security income. You want to kind of walk us through that, because a lot of people think, okay, it's Social Security. This has nothing to do with retirement. We always say that. This is not your retirement benefits. It's a whole different deal. These are basically the two disability programs that the Social Security Disability Association or Administration has. Do you want to
Correct.
talk about a little bit of the differences?
Yes, Social Security Disability, or the Social Security Administration, oversees two disability programs: Social Security Disability Insurance, or SSDI, and Supplemental Security Income, which is SSI. And I think they made them as where their initials were as close as possible, so they could be as confusing as possible. But with Social Security Disability is paid out to you based on what you've paid into the system, and to receive Social Security Disability benefits, you have to have paid a certain amount in over the right periods of time to meet what's called the insured status requirements. And that's I usually tell people when I'm talking to them about it, it's kind of like car insurance. If you pay your car insurance premium this year, a full year premium on today's date, then by this time next year, you got to pay the premium again or you lose that coverage. As long as you're working and paying in Social Security taxes, then you maintain and earning sufficient sums, which if you're working full-time, you're going to be. Then you are getting quarters of coverage and are going to be eligible to receive Social Security disability if you stop working. After you stop working and earning and paying into Social Security, then generally approximately 5 years after you stop working, you will lose what's called the insured status requirements to receive Social Security disability benefits. Now, some never meet the insured status requirements to receive Social Security. They've never worked enough and paid enough in to receive that. Individuals who've never worked and don't meet the insured status requirements for Social Security disability for whatever reason, if they work sporadically or whatever the cause may be, can still potentially receive disability benefits, but they're going to receive supplemental security income or SSI disability in that situation, which is a needs-based program. So they're going to look at not only are you disabled, but what is the what are your resources, what's the income coming into your home, and to make sure you meet the what's referred to as the non-disability requirements for SSI. The disability decision is the same for both. The non-disability criteria is different for both programs from there. Now, the look-back period is not as relevant, especially now that they're going to a 5-year look-back period, is not going to be as relevant to SSI claims as the 15-year period, because you had people who did work and then for whatever reason hadn't worked for a period of time and then no longer qualified for Social Security disability but still qualified for SSI. With the 5-year look-back period, it will still apply to people who had sporadic work from that standpoint. If you work this year and then or for 6 months this year off work for whatever reason, worked another 6 months off work, then and don't have enough that you've paid in that you qualify for Social Security disability, then you would still potentially have the SSI claim. So it's going to apply to those situations, the SSI claimants who have worked in the 5 years prior to their disability onset date. And it applies to the others, but they don't have any work there. Now, if they had work in the 15 years, then it may make a huge difference on those people's claims, because the jobs from 5 years back to 15 years back, those 10 years are no longer going to be looked at.
And friends, if you want some ideas about, well, do I really qualify and how does all that work? You can go back to episode 37, which you can find on Jeff's website, jeffrobertslaw.com. If you go over in the media section on the right-hand side of the website's homepage, just click on media and you'll find all the podcasts. But in episode 37, we have an episode called Qualifying for Social Security Disability Benefits, and that kind of gives you some additional information there. There's also, Jeff, we did this one as a follow-up. In episode 42, we talked about a continuing disability review. Does that have any bearing on this change, or does this change have any bearing on a continuing disability review?
Should not have any change on a continuing disability review, because on the continuing disability review, the person is already on disability, and then they're looking to see if they're still disabled. So the look-back period really shouldn't be applicable. Most of the time, not always, most of the time, continuing disability review doesn't occur until several years after you've started receiving disability benefits. I've seen people, or I've seen things that say, 3 years or so after you're subject to a continuing disability review. My experience has been that normally it's a little longer than that. It's closer to a 5-year period before they look at it. And if they wait 5 years before they do the disability review, then there shouldn't be any work history there, or unless you've engaged in a attempt to return to work, which is fine. You can do that, and there's a trial work period to allow you to do that. But if you're not able to do that, that's not going to be counted against you in the disability review process. There are a few situations where it could come into play. There are times where the individual has a condition that with some treatment is expected to improve with treatment. If you've got somebody who has a significant spinal injury, who qualifies for Social Security disability, but is also maybe facing some surgeries in the future that could help improve their condition. Sometimes you'll see judges put in the decision that this person's condition is expected to improve in the next 12 months or next 24 months is what I normally see, and an expedited review is would be a good idea in those situations. I've had that occur with people who've had significant vision injuries where they were facing corneal transplants or something as well. And so in those type of situations, the judge in the order granting the disability sometimes request an expedited review. And if they do review in 2 years, and depending on how long it took for you to be successful in your claim, but then the 5-year look back could go back to the jobs that you did before you became disabled in that setting. So there is that potential of it having an effect on those cases. Now, it does have an effect on the continuing disability review from the standpoint of now they're no longer looking back 15 years.
Right.
So it does have that effect. If the review is at 2, 3, 4 years instead of going back 15 years, now they're going back 5 years. And so it's regardless if it's a 5-year review or a 2-year review, they're not looking back as far from that standpoint. So it can certainly have an effect in from the standpoint of now they're not looking at the jobs. The same effect as it does on the original claim. They're not looking at jobs done in the remote past or looking at jobs in the more recent past. And if you have none because you've been on disability for 5 years, they're not looking at any of that.
That makes sense. And as you said in episode 42, dealing with that continuing disability review, that's not necessarily a bad thing. That's just the government checking in to say, hey, has your situation actually improved? Could you go back to work? And that's really, and sometimes the answer is no. I'm still at the same level, or maybe I've declined a little bit. So it's just more or less a checkup.
Correct. And it also that's a lot of times it occurs without the person even knowing. They'll look at it and they say, okay, Medicare's been paying. They're still seeing a neurosurgeon for their low back issues or something, and they don't really. The injured, the disabled person never really knows they've done the check, and also you see a lot of times, as I mentioned earlier, the standards change at age 50 and then make a change again at age 55. So if a person's granted at age 50, then by the time there is a change or is a review, there's a change in their criteria, and they're looking at it under the 55 criteria or 55 or older criteria, and so which is a little easier criteria.
It's a little fluid, basically.
Yeah, so it depends on a variety of things on what they're looking at that point in time. As well, there are times, and I've represented people who have received notices that they've been terminated or going to be terminated because the Social Security believes that they now are capable of returning to work. And if that occurs on a continuing disability review, then you can appeal that and go through the process again to be found that you basically to prove that that's wrong, that you are still disabled by Social Security standards to receive disability benefits. And the process for that, if you appeal the termination of your benefits in a timely fashion, the benefits will continue while that appeal process takes place.
That's another way to kind of extend it a little
Correct.
bit, especially if you think, well, I don't know, maybe I'm on the edge here. I don't really know.
Yeah, and I've been involved in some of those where we have argued that the person is no longer, where the Social Security said the person is no longer disabled, and I've been in the process of an appeal on those several times in my career, and frankly, a lot of times Social Security gets that wrong.
Which is
And
good
we've
for the
been
injured worker, good for the disabled person.
good for the disabled
Yeah.
worker, and I'm sure there's probably in my career at some point that I've lost one, but I really can't think of one in the recent past that I've lost in that regard.
At least in the last 5 years, right?
In the last 5 years, yes.
No, that makes a lot of sense. Jeff, down here in Murray, and you've also got the office up in Hopkinsville now in Christian County. You typically are going to work with somebody who's been injured because they've been in a personal injury claim of some sort. So a car wreck, a motorcycle accident, a trucking accident, something like that. But you also handle a significant amount of workers' compensation. And all of those types of injuries, whether it's workers' comp or whether it's some kind of personal injury from a motor vehicle accident, for instance, those all can ultimately result in an SSDI claim, so a Social Security disability claim. And you can actually file all of that together out of this one office, which is, I won't say it's unique, but it's unusual, I would think.
Correct. I handle all of those, and there are some other attorneys that do that, but a lot of attorneys in the personal injury realm, like I am in, either don't handle workers' comp, don't handle Social Security disability cases, or some who will handle Social Security cases only and don't do other types of cases. Some the same with workers' comp and don't do other types of cases. I do all of those types. I limit my practice to an injury practice, but I do workers' comp, Social Security, car wrecks of any type of personal injury, premises liability, etc. But now, a Social Security claim is not limited to just injuries. It can be somebody's disability can result from congenital conditions. It can result from diseases. Chronic kidney disease can result in disability. Degenerative spine conditions can result in disability that aren't from a specific injury. The person, unfortunately, a person can become disabled not just from injuries, but a variety of other conditions as well.
And so the interesting thing is you cover all of those types of injury claims, which again, not every firm does, but you only have one phone number, which makes it a lot easier. So even with both offices, you've got primarily one main number that somebody would call. So if somebody wanted to get in touch with you about one of these issues, how can they contact you?
Phone number to call is 270-753-0053, or if you want to use an 800 number, it's 1-800-844-5108. Rings to the exact same phone. You call my office during business hours, you're going to get a live person to answer the phone 90+% of the time, unless all the lines unless the staff are busy on all the other lines that I do have, a live person is going to be answering that phone call.
That's outstanding. So again, they're going to have the opportunity to speak directly with you at some point here. So it's not like you're getting shoved off to a case manager or something like that. I mean, you've got a motto. You've got a motto for this law firm, and you've really worked on that for a long time, because it's really kind of how you approach the practice of law, which is ultimately, at the end of the day, a customer service oriented job. And a lot of people forget that. Practicing law is about taking care of your client, and you've got a motto that really is closely aligned with that.
I do, and in my office, my clients are not just just a number on the file. In my office, the office motto, or the what we strive to perform for every client, is to provide small town service and deliver big city results. I've used that as the motto, so to speak, for the office for quite a while. And frankly, if you go to the reviews on my on the website, or the reviews on the Google business page for my office, when you see those reviews, Avo and other places have reviews, I think when you see what clients that I've represented say, one of the things you will see frequently is they kept us informed. They always returned phone calls, kept us updated on what was going on in the case, and I think that I've been through these. I've been through I don't know how many hundreds, if not thousands, of workers' compensation cases in my
the
career.
past 32 years.
Yeah, in the past 32 years. Same with car wrecks, same with Social Security, disability, etc. On the cases I handle, but most of my clients, that's the only case that they have. The only time they're going through it is when is the case I'm representing them in. And I know from talking to clients when I was early in my practice working with another attorney, when I first started off, one of the things was that I noticed is the clients would have stress over what was coming. And it would weigh on them, and I understand that from that. And if I were in their shoes, it would weigh on me as well. I knew what was coming because I did. I was handling these cases all the time, so I tried to make sure my clients not only know what's going on right then, but what the next steps are, so that it takes that stress off of them. But trying to recover from an injury. Or if you have a disease and dealing with that is stressful and difficult enough. So if I can take any kind of mental stress off of my clients and cause them to have at least a little bit more peace about what's going on and what's going to be taking place and what's coming up, so they don't have that, I think that's, frankly, I think all attorneys should be doing that for their clients. But I think that's part of my job is to make sure, and my staff's job is to make sure our clients are aware of that. So.
Outstanding. Jeff, it's been a pleasure talking with you today. I know this change in the look-back period for Social Security disability is significant. As you explained, there's some definite advantages for the person who's getting ready to apply for disability, or someone who goes through this continuing disability review that we talked about. So again, great information. As always, I love the way that you just kind of break it down and make it pretty daggone simple, because the law is pretty complex. And I think that's why people sometimes, don't know if they want to get into filing a claim, but in many cases, they really should, because they have rights, they have, benefits that are sitting out there. And if they can get on the phone and talk to you directly and have you kind of walk them through it, I think they'll be more confident in saying, hey, you know what, I'm ready to proceed with this, and let's do this.
Right. I think that, I understand people being reluctant to some extent to come see an attorney. Or to pursue a claim. That's one of the reasons why, as we've talked about in other podcasts, I work on a contingency fee basis. You're not out of pocket to hire me. I get paid at the end of the case. The initial consultation is always free as well. And not just the initial consultation. On cases I'm handling on a contingency fee basis, all the consultations are free until the case is resolved, and I get paid there based on the results I've achieved for you. There are a few cases, very, very few, that I handle on an hourly rate, but even then, the first appointment, when we first talked, that first appointment's not covered, and then they know it's an hourly rate case going in. And that's just because, about the only one I handle on hourly rates, workers' comp medical fee disputes, and that's because I'm not recovering money for my client. I'm getting my client medical treatment paid so they don't have to pay it out of pocket. So
that makes sense. So basically, again, a free initial consultation, free ongoing consultations while the case is going on, which is nice, and then at the same time, no upfront cost. Now, your fees come out of the award of the settlement at the end of the case. There's usually some case costs and other fees and expenses. Those are line itemed on the sheet on the settlement summary, so they know exactly what those are going to be deducted from that as well. But again, there's no cost out of your pocket to hire Jeff Roberts, and that's one of the things that again, a lot of people are surprised about, because they're thinking, well, I hired a lawyer one time and they asked for a retainer and an hourly fee. In injury law, it doesn't work like that, and at Jeff Roberts' law firm here at the Roberts Law Office, it doesn't work like that either.
Right.
Outstanding. Jeff, I hope you have a wonderful week, and we'll be back in a couple of weeks to record the next episode.
Okay. Thank you.
Thank you. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.